This is a pivotal moment in the fight for Federal Reserve independence. President Trump's attempt to remove Lisa Cook, a key member of the Federal Reserve Board, has sparked a high-stakes legal battle that could redefine the balance of power between the executive branch and the central bank. But here's where it gets controversial. Trump's legal strategy hinges on a narrow interpretation of the Federal Reserve Act, which many argue could erode the very independence the Fed was designed to protect. Lisa Cook, who is also a nominee for President Joe Biden, faces a lawsuit challenging her removal. Her lawyers, however, are pushing back, arguing that Trump's request to fire her lacks legal merit. In a recent filing with the Supreme Court, they warned that allowing Trump to proceed would set a dangerous precedent. This court should deny the president's extraordinary application because his arguments defy established precedent and long-standing practice. The crux of the dispute centers on whether Trump has a valid legal reason to remove Cook under the Federal Reserve Act. Trump claims she committed mortgage fraud by misrepresenting two properties as her primary residence. She denies these allegations, which relate to homes in Ann Arbor, Michigan, and Atlanta. However, her lawyers argue that Trump's accusations are flimsy, unproven, and timed conveniently after the president criticized the Fed's interest rate decisions. Earlier this week, a coalition of former Fed chairs, Treasury secretaries, and economic advisors urged the Supreme Court to block Trump's request. If the court grants the president's motion, it could open the door for Cook to be reinstated once the merits of her case are reviewed. This creates a critical dilemma. Should the court prioritize preserving the Fed's independence, even if it means delaying a decision on Trump's legal claims? The broader question is whether the president's authority to remove a Fed governor is absolute. Cook's lawyers insist that the for-cause standard in the Federal Reserve Act requires notice, a hearing, and judicial review before any removal. They argue that manufactured charges, especially those based on conduct from before Cook joined the Fed, do not meet this threshold. Otherwise, any president could remove any governor based on any charge of wrongdoing, they warn. That regime is not what Congress envisioned when it protected the Federal Reserve Board from presidential control. What does this mean for the future of the Federal Reserve? Should the president have the power to remove a Fed governor based on unproven claims? Share your thoughts in the comments. This is a debate that could reshape the nation's financial system.